So I have an update for you on the current ATF battle over pistol braces and the current nationwide injunction against the brace rule. The ATF is now claiming that all of these lawsuits are invalid because it would result in a circumvention of you paying taxes. So let's talk about what is happening. But really quick before we jump into this video, if you agree that the ATF pistol brace rule is clearly invalid, go ahead and hit that like button and subscribe. As I mentioned in the intro, in this video, I have an important update for you on the ATF, the pistol brace rule, and the current battle and lawsuits that are going on. The ATF is currently trying to get out of these pistol brace lawsuits. The ATF is actually trying to get one of these cases thrown out, essentially by claiming that the plaintiffs are engaging in some form of tax evasion. I know sounds ridiculous, but that is now what the ATF is arguing. They're now arguing that you as an individual cannot bring these types of lawsuits because it would result in you circumventing a tax payment. The ATF now claims that they cannot be sued over the brace rule since it would lead to the evasion of paying a required tax under the NFA. This is similar to an argument that was currently made and was recently made in the ATF case about made in Texas suppressors. We've talked about this before. That is the Paxton v. Dettelbach case. It deals with made in Texas suppressors and the current law that was in place in Texas, which aimed to deregulate these types of items like suppressors and silencers that are made in and remain within the state of Texas. This is an argument that was brought up in that lawsuit and was then used by the lower court to dismiss the made in Texas suppressor case because of a lack of standing. Well, now the ATF is trying to do the same thing, but now with pistol braces by making a similar argument in these lawsuits. You may recall that the ATF recently decided to roll the dice and appeal all the pistol brace cases up to the Fifth Circuit Court of Appeals. Those major appeals that we've talked about in the past are the Mock v. Garland case, that is the FPC case, and then also the Brito v. Garland case, which is one of the cases that led to the current nationwide injunction against the brace rule. Then you have some other cases like the SAF, the NAGR, and then also the GOA in Texas lawsuits. Now, although the ATF has already lost once in the Fifth Circuit Court of Appeals in the Mock v. Garland case, the ATF has decided that the lesser of the evils for them was to appeal up to the Fifth Circuit and hope for some form of relief. Now, despite those appeals, which were requested by the ATF themselves, the agency is still trying to get one of the lower courts, the judge there, Judge Reed O'Connor, to issue a summary judgment in their favor. That summary judgment requests for the entire pistol brace case to be dismissed and for the brace rule to be upheld as valid and as a valid agency action by the ATF. This, of course, is a very bold move by the ATF. Essentially, now they're arguing for this lower court judge, Judge O'Connor, who's ruled against them multiple times, to completely just change his decisions, to go back on what he said prior. And one of the main arguments that they are pushing for is the requirement that these individuals here would have to go through a specific process if they wanted to bring these lawsuits because a tax payment is involved with this new rule. The ATF is now arguing that these lawsuits are invalid and cannot be brought since it would result in a statutory violation and circumvention of a taxpayer paying a required tax stamp under the NFA. What this argument kind of amounts to is the ATF claiming to the courts that they cannot ever be really sued as long as they require a tax stamp under the NFA attached to whatever rule they are making. And in fact, this is kind of the type of argument that they already made and were kind of successful on in that Texas suppressor freedom case. Now, if you're not aware of why the ATF is currently getting so desperate with some of these arguments, that's because recently in the Brito v. ATF case, Judge Matthew Kaczmarek issued a preliminary injunction which blocked the brace rule in its entirety while the case proceeds forward. This decision by the judge there, Judge Kaczmarek, springboarded off of a different decision in a recent decision by Judge Reed O'Connor in the Mock v. Garland case. However, in the Brito case, the judge there, Judge Kaczmarek, went the extra mile and granted the request for an injunction against the entire pistol brace rule, and again, that was a nationwide preliminary injunction. Now, in that decision by Judge Kaczmarek, he stated that the court is certainly sympathetic to the ATF's concerns over public safety in the wake of tragic mass shootings. The rule embodies salutary policy goals meant to protect vulnerable people in our society, but public safety concerns must be addressed in ways that are lawful. This rule is not. In the Brito case, Judge Kaczmarek granted the preliminary injunction striking down the pistol brace rule entirely nationwide. Again, that was a huge win. And then after that Mock win, and then after the Brito win, the question was, what would the ATF do? Well, the ATF decided to roll the dice and appeal once again up to the Fifth Circuit Court of Appeals, and they're now seeking relief in multiple cases. Now, recently, all those cases were consolidated together, and the Fifth Circuit will decide and rule and hear those cases all together. This move by the ATF is of course very risky because again, they've already lost in the mock case in the Fifth Circuit before. And so really all the Fifth Circuit is going to look at is some of those three remaining factors for, whether an injunction should have been granted. So that is kind of putting the ATF in a very bad situation and kind of shine some light on why they're so desperate in these cases going forward. But on top of all of those appeals, the ATF is now asking for a motion for summary judgment in the lower court in front of Judge O'Connor. And one of their primary arguments is, in fact, taxes. They make an argument that this lawsuit is barred from being brought on review by any court because the plaintiffs aim to obstruct the collection of the NFA's required taxes. The ATF claims that under the Tax Anti-Injunction Act, Americans cannot sue the ATF to stop the pre-enforcement of this pistol-brace rule, or maybe any rule that they attach a tax stamp payment to. Instead, the ATF argues that the AIA requires individual taxpayers to go through the NFA process, register maybe their braced pistol as SBRs with the agency, and then if the individual doesn't like paying that tax, they need to seek a refund, and that needs to be a refund that goes to the Attorney General, and that needs to be that request that goes to that office. And only if that office decides to deny the refund, then can the individual person sue individually for the recovery of the tax payment and that payment that was paid to the agency, but only then can they bring a lawsuit. The ATF states in their brief that rather than bringing a prepayment challenge, a taxpayer's principal mechanism for disputing the assessment of a tax is a refund suit. And in the NFA context, specifically, the maker of a firearm who wants to challenge the assessment of the NFA's tax against him must first pay the tax and then file a claim for a refund or credit with the Attorney General. If that claim is denied, the maker may then bring suit in federal district court to recover the sum. That refund suit remedy offers a taxpayer a full, albeit delayed, opportunity to litigate the legality of a disputed tax. Therefore, the ATF states, to the extent plaintiffs seek relief that would directly restrain enforcement of the NFA's tax against any braced equipped pistols, asking to enjoin enforcement of the NFA against plaintiffs' braced pistols, those claims are barred under the AIA's plain text. Of course, this is a very absurd argument to make, but it's similar to what the ATF recently made in the Made in Texas Suppressor case, Paxton v. Dettelbach. It's a case we've talked about here on the channel before. The ATF made a very similar argument to why the plaintiffs in that case, in the Made in Texas Suppressor case, did not have standing, and therefore actually the lower court on review did decide in the ATF's favor. They ruled in the ATF's favor, and they dismissed the case for a lack of standing. Well, now the ATF is trying to make a similar argument with the pistol brace case and the whole pistol brace rule and SBRs, saying that based on the AIA and the taxes involved, the plaintiffs there, can't bring this lawsuit. Maybe that they don't have standing, that the court doesn't have jurisdiction, and therefore this case should be thrown out. Now, also interestingly, in this brief, the ATF actually admits that they've made multiple errors with the pistol brace rule, but many of those errors they claim were unintentional and should be ignored by the court. They also argue that the ATF's current position on braced pistols has changed. Their position on them being SBRs has changed dramatically over the years, but they argue the court should disregard any prior guidance because any prior guidance was incomplete, and therefore the court should only look at what actually the ATF is saying now, which again is kind of hilarious. And it's of course the ATF is making this argument because they want to be on the position that they're on now, despite the fact that multiple times in the past, multiple guidance letters, multiple situations, the ATF has said no braced pistols are not SBRs, but now magically because they want to violate our rights, they are saying that they are. In all reality, I think the ATF is just scrambling in all these cases. They have been backed into a corner because of the multiple lower court decisions by Judge O'Connor and then also Judge Kaczmarek, and also the Fifth Circuit's initial review of the injunctions has pretty much put the ATF in a very bad situation. So the next best thing they can do is go back to the lower court, ask for a granting of a summary judgment on a theory that they've used prior that did result in a favorable decision against the Made in Texas Suppressor case. So now they're just touting out this big argument about taxes, how this would be a circumvention of the payment of a tax. And hopefully, for them, what they're hoping is that the court here will look at this tax issue and say, well, yeah, we don't want, people to avoid paying taxes. Look at this other statute that says you can't bring this type of, litigation if a tax is involved, and therefore I'm going to dismiss this case. Now, I don't think that Judge O'Connor is going to buy that argument, but that is the argument that the ATF is now making. And so that's kind of the current status, but we have multiple injunctions right now which are barring the enforcement of the brace rule. Now, again, that could change very drastically fast, especially based on these new arguments that the ATF is making. So if anything else changes, I will let you guys know. Make sure you're subscribed to the channel, have on all notifications, because that will ensure that if anything changes, you will be notified. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.